Okay, hi everybody. My name's Chase Silvert. I do hope that you should see alternatives to guardianship on your screen in big letters. I'm seeing head nods, so I think we're good. Um, okay, so I am with the Hawaii.
Yes.
I'm sorry, do
I
you guys
don't
get any
want you to
feedback?
have your.
Okay. So I am with the Hawaii State Council on Developmental Disabilities. I am our legislative and community liaison. It just basically means I do all of our policy work. We've been working on alternatives to guardianship. Some spoiler alert is like supported decision making is a big one of those. So we're going to start with basically before we can talk about what the alternatives to guardianship are, we need to kind of understand what guardianship and conservatorship is. For today's kind of PowerPoint slide, we're going to be looking at an overview of guardianship and conservatorship. We're going to be looking at supported decision making, which is an alternative. We're going to also be looking at a power of attorney, which is another alternative to guardianship. And then, as Amanda had kind of already alluded to, we will also be covering, things like able accounts, representative payees, things like that as well. I know we have a sign language interpreter. I usually speak really quickly, so I will do my best to not do that as we go forward. So, what is guardianship? From what I understand, it sounds like Amanda has already talked about this a little bit, but just to go into a little bit more detail, guardianship is also tied specifically to conservatorship. So, there's two sides of the coin when you're speaking about these things, and they are different. They are separate technically. You can go to the court and request for both of them at the same time, so you can get guardianship and conservatorship of somebody or you could just get guardianship or conservatorship. And we're going to go over the differences right now. So for guardianship specifically, this is basically becoming somebody's decision maker for day-to-day life decisions, medical decisions, where I want to work, what I want to do, those types of things, where I want to live. Those are the types of decisions that a guardian gets to make. A conservator gets to make all the financial decisions. And it's a little confusing because it does sound like they kind of overlap, right? Where I want to live might cost money and things like that, which is why oftentimes they're tied together, but they can be done separately. So with conservatorship, it's going to be how do you spend your money? How do if you work a job, what do you do with your paycheck? Things like that. So that's just like the small difference. Like I said before, oftentimes people go for both, but if you do not, it is completely possible to be someone's guardian and they still have financial control, and you can, and they still have financial abilities, and they can have a bank account and do those kinds of things. So for types of guardianship specifically, this is actually something not very well known in the state of Hawaii. We actually have three types of guardianship, even though mostly only full guardianship is used. There are three types. So full guardianship is exactly what it sounds like. You take full guardianship of another person. You take all of the decision-making capacity away from them, and you make all the decisions for them. Limited guardianship is also how it sounds, which is that there are certain decisions you can make for them and certain decisions that they still get to make for themselves. That one is a little more complicated, especially because guardianship and conservatorship always goes through courts, right? So when you go for limited guardianship, you kind of have to talk with the court on, well, you know, I think that they can make decisions about, what they eat day to day and what they do, but I want to be able to make like the where do they live, where do they work, like the bigger decisions. So you can kind of work that out in limited guardianship. And it's all part of the agreement when you leave the court if it works, and it's all written down and very clear. For temporary guardianship, I think this is what gets misunderstood the most. Temporary guardianships are essentially emergency guardianships. And the emergency guardianship is never going to last for a long time. These are typically only granted for very short instances of time. That's the point of these. The best example is if somebody is they have no next of kin, they have no paperwork signed for like a power of attorney, and they become medically unconscious, or there's some medical problem and they lose the capacity to, speak or make decisions or, do things like that. You can then get a temporary guardianship over that person to then make those medical decisions for them. That's essentially the use case that it was designed for. So don't think of temporary guardianship as like a tool to kind of get around the process, which has been used in the past. It just won't work because it only lasts a short amount of time. We have conservatorship, which is kind of, as I said before, it's specifically financial. It's just all the financial decisions. If the person gets SSI, you take all that money and then you're the only one that can spend it, or at least allow people to spend that money. And again, this is why oftentimes if you go the guardianship conservatorship route, they're lumped together and you get both of them. So given that that's conservatorship and guardianship, we wanted to start talking about the alternatives to it as well. So this is just kind of a sneak preview. We'll be going into more detail into most of these. And I'm always here to take questions. You can always reach out to our office and we can have a conversation and talk to you about more for anything. So for supported decision making, we're going to go into a lot more detail on this one because it is the best and promising practice coming out around the country for alternatives to guardianship. And in a nutshell, what supported decision making is just it is supporting an individual to make decisions with either another person or a group of persons. So anytime they want to make a decision, they have to consult what we call their supported decision maker, and they kind of just have to talk it out and figure out what's best. And whatever they both decide together is what the individual is going to do. That's like the most simple way I could put it. Power of attorney is another, legal way of signing a document in which you then become a surrogate decision maker for somebody. Now, we'll get into some nuances in this in a little bit, but with power of attorney, the big difference between power of attorney and guardianship is that at the end of the day, the individual still has the right to make decisions, and their decision still is the most powerful. So if there is a disagreement, the individual's choice is what is respected by the law, even if there's a disagreement. But power of attorney is a great thing if someone has a medical problem and they're incapacitated, it allows somebody else to make decisions for them, all these things. We'll get into those in more detail. We have things like release of information and protected health information. These are for scenarios where if you're not directly related to the individual, many people, you have problems with the healthcare field and the financial field and getting information about them. And so if they're okay with it, they can sign these releases, and then you, even as a non-blood related relative, can get that kind of information. Because we know a lot of people get guardianship and conservatorship in those scenarios where that might be a problem. We also have living wills or advanced directives. We have advanced instructions for mental health treatment, and we have legal and healthcare supports. And so, like I said, we're going to go into more detail on all of these. So, for really quickly, for power of attorney and educational representatives, and I will always, for this, defer typically to Amanda and Susan when it comes to the educational representative, and I highly recommend you guys talk to them if that's something you guys end up wanting to do. But the big difference is that with the power of attorney for special education, you're basically just making a power of attorney for people that are still in the DOE system, but it works very similar to power of attorney, which is that you don't make all the decisions for them, but you can make decisions for them. So you can speak for them. You are a surrogate decision maker. You can sign things for them. But in this scenario, they can still do those things as well. With an educational representative, this is really the more severe one, which is just, if the student cannot make decisions, this is the route you take because you will be making those decisions for them in the DOE setting. And these are just really specific to school settings. Once they graduate, there's other things that you can do and other alternatives, but these are the ones that you can do while you're still in a school setting. So we're going to go more into supported decision making. I already gave you guys a little bit about what it is, but so supported decision making is a process that just allows the individual themselves to make as many decisions as possible, on their own and with supports. It's something that we always recommend that people try before guardianship or conservatorship, or you can use it in conjunction with those things, and you can use it in conjunction with power of attorney. It's not meant to be an end-all be-all process. It's also not meant to be a one-size-fits-all. This is not going to work for everybody. This is just something that we recommend you try or you try it in conjunction with other things. It's supposed to be, it was actually originally developed just as a process of working with people to make decisions. So you can do it with someone that's under guardianship, right? And it's just going to allow them to make as many decisions as possible. And then when it doesn't work, that's when guardianship could come in handy. So we always just recommend you start here and you start this process. So, some of the pros of supported decision making is it promotes independence and self-determination. It encourages inclusion. It's supporting the individual's right. We always like to make this point, which is that, technically speaking, when you are seeking guardianship or conservatorship, you are stripping a person of their rights. That's like the whole point of the court process. So you're stripping them of all of their rights, like sometimes even including the right to vote, for example. And that is what that's doing, where supported decision making is not technically going to do that. But like we said before, it can be used in conjunction with those things. And that's why we do like it as a best practice. So just really quickly, kind of how supported decision making works is you pick someone you trust. So this can be, your uncle, your friend, your best friend. It can be all these different people in your community. We also really like to clarify that it can be multiple people for different things. So I can have somebody help me make medical decisions. I can help somebody make financial decisions. I can help somebody make, very specific things. So you don't have to have only one supporter. It can be a whole community around you and everyone's doing what they're good at, right? A good example is on the mainland where they've been using this a lot longer than we have. There was an individual who had their case manager be their supported decision maker specifically for healthcare matters. And that person would actually go to doctor's visits with them, have those discussions, and help them make, informed decisions was essentially the goal. So you pick a supporter, you decide how they're going to help you. And then it's basically, I don't want to say it's that simple because there's a lot of nuance to it, but you basically talk story with them and you make decisions. And the thing that we want to clarify with support decision making is it's an agreement. It's so some things that we've done in Hawaii the last couple of years is that we actually got supported decision making codified in our laws. And I have a slide about this later where I can show you the link and the law that was passed. But the reason we did that is that this is a legal agreement, just the same way that a power of attorney would be a legal agreement. And so you are agreeing to this process as the individual and the supporter. And the whole point of that, and the reason we wanted to make it a legal document was a lot of people have told us that the reason they go for guardianship or conservatorship or the reason they become power of attorney and things like that is they really just want access to, health documents, financial documents, and things like that, which is completely reasonable, especially when you're trying to help an individual, with intellectual or developmental disabilities. And so this document actually allows you to get all that information. It would allow you to work with the banks and see the finances. It would allow you to have medical information on the individual. And if the individual becomes unconscious and things like that, this document would let you visit them and talk to them and do those kinds of things. Where if you were a non-blood related family member, you may not have that access otherwise. And so signing this document does allow you to do that. One note, and I think Amanda had to kind of mention this a little bit, is, especially with supported decision making, this is instant. We have a document that you can sign today and you can start doing this, where guardianship can take 4 to 6 months at this point, due to our courts being overburdened, and it can cost several $1,000s. This does not cost any money. And so even if this is used as a stepping stone before those things, because it's immediate, it's a good use case. And before all of that, it's just a practice as well. Like we can't stress enough. You can use it with guardianship. You can use it with power of attorney. You can do all of those things, and we support any of those things. So there's a QR code on the screen. I will make sure that two things. I will make sure you folks get this PowerPoint. I will get it to Amanda and she can send it out. But two, when I'm done talking, because I don't have too many screens, I will actually put documents in the chat of the supported decision-making agreement, link and things like that, and a toolkit that we have. So I'll make sure you guys have everything that I talk about. So don't freak out if the QR code either doesn't work or you can't get your phone out. But so we have this QR code should send you either to directly a document that has the support decision making agreement, or it's going to send you to a website that has a link that just says, support decision making fillable agreement. And so we made a specific document that you can just form fill in, have everybody sign at the bottom, and now you have a recognized support decision-making agreement. We are still working with the banks and the healthcare center to make sure that they really know what this is so that they don't question it when they see it. So really, you should be able to show this to a bank or to a hospital worker, and they're not going to question that you have rights to that information. It doesn't mean, now we should clarify, it does not mean you can make decisions for the person, right? That's not the point of a support decision-making agreement, but it does give you the right to the information. So I can see how much money's in their bank account and how many bank accounts they have. I can see their medical information and help them talk through those kinds of things. So as I kind of mentioned, we have a support decision-making toolkit now. So this is a 20-page document that, like I said, I will link in the chat when I am done speaking. And it is basically just a follow step-by-step document. You start here if you want to do it. It should walk you through everything you need to know about support decision-making, everything you need to do for it. And by the end of it, you should be able to do support decision making, or at least know if it's right for you or not right for you. And it has all the links and the resources and all those kinds of things. So I'll make sure that will be in the chat as well. As I mentioned before, we had some support decision-making legislation. So this wasn't legally recognized in Hawaii until last year. It was HB 320 that turned into, I believe it's Act 284, but don't quote me on that. And so now it's legally recognized, which is a big deal. I think there's only 10 or 15 states in our country that legally recognize it, but there are something like 30 or 40 states that do the practice. We're just one of the states that legally recognize it because when we spoke to the stakeholders, a lot of people expressed that they wanted access to information with these agreements. And so it had to be codified legally to be able to do that. So moving on from supported decision making, we have power of attorney. So power of attorney is kind of similar but different, which is that it's also a signed legal document. And once you sign this document, you become the surrogate decision maker for somebody. Now, like I said before, I think the biggest clarification between this and guardianship is that at the end, if there is a disagreement, at the end of the day, the individual's right or their choice is what is going to be respected. Now, that doesn't stop you, though, from if you are the person's power of attorney, you can sign documents, you can make decisions, you can do all of those things with a power of attorney. And again, it's a useful tool because it's the same thing with support decision making, and you can couple it with support decision making as well. And the reason you could do, I guess the reason we bring all of this up is instead of doing like a guardianship conservatorship method first, you could always try a supported decision making, power of attorney, able account kind of setup, which would then almost give you the same authority as conservatorship and guardianship, but they're all free and they all can be done within a week. Where guardianship and conservatorship can be like $4,000 because you typically have to hire an attorney and it can take 4 to 5 months to do. So those are the big differences. We just wanted to, this is kind of what I just said, but we're just highlighting that with support decision making, there's no court involvement. Neither is that for power of attorney, but with guardianship and conservatorship, you do have to interact with the courts and go that route. So for some financial tools, and I see I have about 4 minutes left because I want to leave time for questions. I'm really going to focus on able accounts and representative payees because I think they're typically the most relevant for people. We have a lot of information on trusts and special needs trusts and joint bank accounts and things like that. If you need something like that, at no point am I trying to say I'm providing legal advice. We can provide you with the resources to know what those are, and if that's something you want to look at, you can always contact us, and we can talk more about you. We cannot recommend like attorneys directly, but we can point you in the right direction, and we can give you the lists, and we can help you with that process if that's the direction you want to go. So for able accounts, I know Amanda already spoke a lot about these, but like she said, you can save up to $100,000. You can contribute up to 19,000. Now, the number is about 25 or 26,000 a year if you're working. So the 19,000 is for non-working people, but the 25 to 26,000 is for working individuals. So it does get higher. The whole point of these accounts is that they are basically ways that you can make income and have savings without it affecting your Social Security and your Medicaid. So, as an adult, if you're working, this is a great way that you can have some income, you can have some savings, and you don't immediately get kicked off Medicaid. I will say a little caveat here, really quickly, is that we are working with the Department of Human Services to remove the Medicaid income requirement. So we're hoping that that won't be a problem at all, but these ABLE accounts will still be very useful. ABLE accounts do have some limitations. So you can technically only spend ABLE accounts on these things. However, what we found in practice is that they're so broad that you can really spend an ABLE account on really anything and justify it. So I wouldn't worry too much about that. This should be a link to how you can open Able accounts at any time. You can email or call us. Daintree, my boss, is really into these Able accounts, and she will literally sit on a Zoom call with you and help you open an Able account and do step by step. And I do apologize if my throat is cracking. I've been sick for a long time, and I just talked for a very long time. Okay, that is everything. I'm happy to go into more detail. If there's any questions, please just let me know.
Shay, you do have a question. It was, can a 529 account be converted into an ABLE account?
I believe so. They are technically from the same type of account. They're technically both 529 savings accounts. You can transfer.
And there's another one. What are the cons of an ABLE account regarding Medicaid payback risk?
Okay, thank you for mentioning that. So there is something called a clawback clause, which it's a little bit of a disingenuous thing because while it does exist and while it does say that they can do Medicaid clawback, which for people that don't know what that means, is essentially if you have an ABLE account and you're getting Medicaid, which is why you have an ABLE account, Medicaid can claw back some money from your account if you pass away and there's money in the account, and to pay for whatever services you received. Now, this is something that rarely happens. And when it does happen, it's not like they empty the bank account, they just take a certain amount of money. So it's very rare that it happens, but it does happen, and we're not going to say it doesn't happen. But it's very, the risk versus reward is kind of something you have to balance. And it just doesn't happen.
There was another question when you were talking about the alternatives to guardianship, and then Susan Rocco mentioned that the individual needs to understand and what it is to give permission to somebody else to make decisions for them. And then there was a question, if the person doesn't understand what it is to give permission, what is the alternative?
Okay. So I guess our take on this is, and like I did try to express, is support decision making, guardianship and conservatorship, power of attorney, ABLE accounts. They're all things that you can use in conjunction with each other. And there's steps you can take. So if you have the time, if you have the luxury of time, and by that I mean, if your kid is not turning 18 next month and you can go through some steps and you can try some things, we just encourage that you try support decision making and see how it works with your individual. Oftentimes, we found that people are surprised by the capacity of somebody to be able to make decisions with a supporter that they respect. Other times, it doesn't work for people, and then they need guardianship. So, oftentimes, we just recommend you try it. And then when it doesn't work, that's when guardianship and conservatorship becomes an option. A good example is, if you try support decision making and they just continually disregard anything that you guys talk about, we agree to do X and then they do Y and they do that 3 or 4 times. Well, then that's not a person who's meant to do support decision making. It's not going to work for them. I hope that kind of answers the question.
Thanks, Jay. And then I think we have one more here. I can't remember if this got answered. Can a 529 account be converted into an
Yes.
ABLE account?
So I think the caveat, because I did answer that a little bit, as I don't know if it can be converted, but I do believe you can like transfer through them because they're both the same type of accounts. Daintree knows a lot more about that. So if that's a specific thing that people want to do, you can contact us and we can walk you through it.